Yes.
Good afternoon. I already raised this question with Patrick because Patrick, thank you very much for that very enlightening and I'd say very superb presentation. I noticed that the Japanese hired a foreign advisor. I don't know how to pronounce the name, but it's Buwasanad. Okay, but in your presentation, there seems to be an absence of a foreign counterpart in the Imperial Qing court. How would you explain this? And why is it that, in a sense, Buwasanad was effective with the Japanese, but on the other side, as far as the Chinese are concerned, there was practically no mention of the foreign advisors and its influence in the Qing court. Thank you.
Thank you. I think that first of all, we have to make a comparison between the Japanese character and the Chinese character in the late 19th century. As Professor Kati mentioned in the last presentation, Li Hongzhang and the Chinese officials did not take international law seriously. They thought that the Chinese culture was superior and they did not have to apply a foreign system for their sake. They just used international law as some measures of negotiation, but as a temporary measure. But they did not want to use the international law system to replace the Chinese tributary system. And in comparison, I think that the Japanese government, because Japan was smaller in size, and they have to carry out rapid reforms to resist to the foreign aggression. So they were willing to adopt the international legal system, and they even thought of using the international legal system to replace the tributary system so that they could construct a new hegemony in East Asia. And you just mentioned that why there was no counterpart of the Japanese legal advisor in China. I think this is the reason, because they didn't take international law seriously. And at the same time, Japan was not adopting completely poisonous suggestions. They just adopted part of this, for example, sending agents there to carry out reforms, to inspect the land, and to require the Ryukyu king to go to Tokyo and acknowledge the expedition of Taiwan. But on the other hand, they didn't want to take poisonous advice to negotiate with the Chinese government. They just want to deceive the Western powers without getting Chinese intervention. Thank you.
Perhaps a rather little question, which sounds perhaps a typical lawyer-like. I wonder if as regards the crisis of the Ryukyus, the title says that the Confucian world order had been challenged and defeated by Western Japanese imperial international law. I'm just wondering, was it really the Western international law that challenged the Confucian world order, or was it rather a false application of the Western international law? I mean, if you take the precepts of Western international law seriously, and if you consider all the evidence, as far as I can judge, as someone who's not familiar to the precise situation, but it sounds as if even under Western international law, there would have been a good case for a Chinese legitimacy of Chinese relations to the relevant island group. So I'm wondering a bit if that was really, or if the Chinese were more disappointed by the Western international legal system or by the Western politics?
I think that the cultural reason is still important, but they have to be the reason for them to adopt international law to protect themselves and to defend their stance was that they were defeated by the Western powers and they were then forced to accept the international legal system because at the beginning they thought that the Western they didn't want to learn from the Western weapons, but they were forced to do so. And then they were also forced to adopt the Western legal system. But at that time, if we take a look at the intellectuals at that period, they were insisting on keeping the Chinese spirit while using some Western tools as temporary measures to resist foreign aggression. And at that time, they have to win foreign support to negotiate, to gain the American mediation. So I think that they still have to use international law to defend themselves. But they if you take a look at their mentality, they didn't want to take it seriously. Thank you.
Because nobody wants to ask a question, I'd rather throw one. Okay. We are all, I mean, me also, we have a very emotional take on colonialism because we also suffered from the European powers. So I can understand Chinese suspicion on international law and its ramifications to the order in the Asia Pacific. But is this particular suspicion still there? Because I know of some Chinese writers who are already making a case that international law is now a common project. Okay, it's no longer a Western project, but a common project, or in fact a common heritage. Would you say that this suspicion is still there, and how would it affect the future of international law?
Sorry, may you simply repeat the question? What's your question?
Because we are proceeding from the thesis, okay, that with international law being a Western conception is predatory, and guys like us who suffered colonialism had, of course, even up to now, we have this suspicion. So how does the Chinese deal with the suspicion in relation to the take now that international law has already evolved beyond a Western conception, but it's now in fact a common project, okay, not just for the Chinese but for the international community of states. How would you take in that suspicion in relation to this common project of international law?
Thank you, Herbert. Well, Patrick has invited me to respond to that. I think that, and there are much more authoritative people in the room to answer this question than myself, Dr. Yiping, Professor Yiping, and Hu Hanan, who will soon be a doctor. But I would say that this is in my judgment, I am still very struck by the remarks of Hu Hanan, my PhD student, from whom I learn an enormous amount, in her thesis, where she says that the Chinese have not internalized Western international law the way that the Filipinos and the Malays and other countries may have, and Japan especially. And I think there is plenty of evidence in Chinese state policy and in declarations that they adhere to some of the features of traditional Chinese thinking about a world family of nations, and indeed the way China itself is guojia, and that they should have partnerships and friendships with countries rather than treaty alliances and so on. But I think that at a fundamental level, I am, and I pay tribute to Jan Nyman here, because this is originally fundamentally her project, is to take issue with the whole ethical foundation of international law by challenging Richard Tuck's characterization of it. Being myself a realist and a cynic and a bit morally lazy about issues, but quite happy to beat the drum of doom and destruction as a critical legal scholar. I mean, I drank up Richard Tuck and I thought, by God, he's spotted what these gangsters are really up to. But really and therefore I regard Western international law as it has hit China and as has been so passionately and brilliantly described by Lucy Chi in her paper. The Western international law is an instrument of bandits. It's a form of banditry from which Philippines has suffered more than China. And so I don't know why the Philippines is on the side of America here. It's on the side of its tormentors. And so there is really a need to rethink the ethical foundations of international order. And I think the lesson from the early Renaissance presentations of Christoph and Susan and many others is to reject the modernist distinction between law and morality, and to see law as jus, as a concept of justice, as a concept of equity, equitable relations among peoples. There was a great French legal philosopher and historian called Michel Vili, and he said that the essence of the Roman law notion of law of jus was a right proportion among peoples, a proportion, what is fair to have as relations among people. So I see our project in its most idealist aspect, and in particular in the reflections of the many European and American scholars, as rethinking a foundation of international law in terms of the Northern humanist, and then trying to reconnect. I know this is very eclectic and is neither philosophically nor historically sound. It's a form of political pragmatism to connect with positive themes of whether Confucianism or Taoism or Buddhism or whatever, maybe even Islam, which is a significant force in East Asia, to reconstruct a notion of international order, which will have very little to do with Western international law, which I regard in my first book, The Decay of International Law. I regard Western international law as of very little value. And it is actually an instrument used to delegalize people, to outlaw people. It's an instrument of the strong to intimidate and marginalize the weak, and that is what it continues to be. So we hope to have, I mean, this is an endless quest for me. We hope to have maybe another workshop, depending on resources, but another workshop which would try to reflect on the experience of China and international law that we have been doing from the perspective of third world legal scholarship. There is a whole movement of scholars from Afro-Asian countries who call themselves the third world legal scholars. They're actually led originally by David Kennedy in Harvard, and it's a branch of critical legal studies. But it tries to look at international law begs a lot of words. International order from a third world experience. And there are people in China like Dr. Yiping and her colleagues who are also interested in exploring alternative. So that's a very long answer. The question, I would resist very firmly the idea that international law is a good thing and that therefore recalcitrant countries, which appear to be troublemakers, have to be bullied into observing international law, otherwise they will enjoy an outlaw status. For me, as a critical legal scholar, there are a lot of rhetorical games going on there, which have to be exposed and resisted.
I have a suggestion for Lucy Chi. I found your paper, although I haven't read your paper, but your presentation really fascinating. I think the research has been really well done, and there's much to learn from your research. But one problem with your paper, I guess, is that you translate all the Chinese Neo-Confucian philosophical concepts, terms into English when you translate like a Li into reason, Gong into justice, Shi into power, and then at one point, okay, Fa is Li, principle, right? Li, there is just somehow, again, I mean, if we, I mean, obviously there is almost these two counterparts. I mean, the Chinese diplomat and French diplomat, whoever, I mean, the Western counterpart, have great difficulty in communication because their reference is widely different. Whenever Zhengji would keep talking about international relationship with reference to Neo-Confucian philosophical languages like Li and Gong, he had this Neo-Confucian metaphysics, right, and cosmology as background, right, and using these concepts to convince these non-initiated, right now, the Western, diplomat. And if we translate Li as reason and Gong as justice, if you just read the English translated scripture, I don't think there's it's easy. I think I would say it's very easier. It gets much easier for the Western diplomat to make sense of what this Chinese diplomat is trying to say. But apparently, Chinese diplomat is saying something totally different. So that the interlocutor has great difficulty to make sense of what he's actually talking about, right? So first of all, like a tributary system understood by Chinese Neo-Confucians with reference to Li-Chi metaphysics, right, and Li metaphysics. And they had their own very coherent philosophical worldview and metaphysical worldview about, what the international relationship looks like. Even 17th century, 18th century, because they've been encountering with the, non-Chinese or non-East Asian people, and they've been struggling with all these problems. So, but whenever they approach these issues, their reference was always to Neo-Confucian metaphysics rather than this. And then tributary system is one manifestation of Neo-Confucian metaphysics. So my point is that translation got to be really accurate. Nobody, I mean, as far as I know, nobody in Chinese philosophy or East Asian sinology translate Li as reason. I mean, that's really, really problematic translation. I mean, so you got to be very clear, or Gong, justice, you got to be very clear how to translate these terms consistently with reference to Neo-Confucianism. And perhaps you might want to show at one chapter very briefly, these are the concepts that used to make sense of, traditionally make sense of East Asian interstate or international relationship. Or these people are using Li, Gong rather than law or whatever the concept that Westerners, groceries or otherwise use. And then you can try to show what happened between these two parties, right? The Chinese people and Western people. What kind of conversation was unfolding? What was the problems? Why did these people have difficulty understanding what was problematic on the part of Chinese diplomat? Only then we can see clearly what was really going on. Otherwise, if we I mean, obviously it's going to be published in English. Then if you just read the English translation of Chinese original China text, it's really, really different from what these people actually said. If we just read the Chinese original text, right? So my suggestion is that you might want to take some time to translate these important classical Neo-Confucian philosophical concepts appropriately, and then show us, the readers, what kind of worldview these people were immersed in, and then from where they actually, came out and trying to negotiate with Western interlocutors. That way, I think the readers would be much better in understanding what you're trying to really say here.
Well, that's to you.
That's a very interesting point from Professor Kim, and I'm sure I learned a lot from your comments. But from my experience in translating these archives, it's very difficult for me to find a translation, a proper one, for the character Li, but it frequently appears in the archives. I think if you treat my translation as some kind of a symbol, an icon, something empty, I think it's actually rather easier, because from the eyes of the French, they do not understand what it really means. So for them, it's just an empty concept. Like what the French said, it's fictional. So I think my translation, of course, it needs polishing, but at the moment, I prefer using the word reason. Thank you.
Point was, anybody who's familiar with the East Asian philosophical tradition, the kind of text that you provide us, I mean, in your writing, just fascinating. I mean, the way they make sense of international relationship with reference to Li and Kong, I mean, all these traditional neo-Confucian philosophical jargons is just really, really fascinating. So my only hope is that only if you can present this material more intelligently, then it would be much, much better, I mean, in communicating with not only legal scholarship, but also philosophical scholars, because they are much more rooted in the classical text.
Do you have any more questions for our panel? Well, first, let's thank this panel for their excellent work, their detailed papers, and the thought-provoking ideas that you've given us to think about. Thank you.